Welcome to Florida Appeals Journal. This is a podcast, and today we are going to talk about hearsay, an update on the business records exception, because we've had some new law developed in, 2020 and 21. So litigators need to know about that. So let's talk about it. Are we all familiar with the business records exception to the hearsay rule? Okay, provides for the admission of, quote, records of regularly conducted business activity as follows. I'm going to quote the rule for you. We all know 90.803, 6A. A memorandum, report, record, or data compilation in any form of acts, events, conditions, opinion, or diagnosis made at or near the time by or from information transmitted by a person with knowledge, if kept in the course of a regularly conducted business activity, and if it was the regular practice of that business activity to make such memorandum, report, record, or data compilation, all as shown by the testimony of the custodian or other qualified witness, or as shown by a certification or declaration that complies with sub C and section 90.902.11, unless the sources of information or other circumstances show a lack of trustworthiness. The term business, as used in this paragraph, includes a business, institution, association, profession, occupation, and calling of every kind, whether or not conducted for profit. So, you're going to have documents generated by businesses. To get those in, you got to get them under the business records exception to the hearsay rule. And there are certain requirements, statutory requirements, that you're going to have to adhere to. And then just remember, while you may be able to get documents in under business records exception, you can have hearsay within those documents. So you got the first level of hearsay. This is an out-of-court written statement, right, for the business. Then you can have hearsay within hearsay. And that hearsay within the hearsay is, again, going to have to meet a hearsay exception to get in. But that's something just to bear in mind. All right. So to admit these documents, these business records, pursuant to the statute, a party has to lay the foundation. You lay it in three ways. First, you can do it through the testimony of the records custodian. Second, you can present certification or declaration that each of the elements has been satisfied. That's laid out in the statute. Or third, you can obtain a stipulation of admissibility. So oftentimes you get cooperation from the other side, again, depending on the issues involved. But a lot of times it could be hotly debated in certain commercial cases, especially. So you want to know your rules. Okay. So there is a case that came out you want to be familiar with. It's the Jackson v. Household Finance Corporation, 298 Southern 3rd, 531. And let's see that. I want to say that was in 2020. Yeah. And then you have cases following that came out. I know the third put something out in August of 2021, United Automobile Insurance Company, 322 Southern 2nd, 1232, again, 2021, really emphasizing this new ruling in Florida on how you're going to interpret a certain part of the business records exception. Okay, so and Jackson overturned the Maslach case, and that was out of the 4th, 197, 3rd, 656. That's 4th DCA 2016. So it went up on conflict. There was the 4th DCA ruling, which again interpreted the statute one way, and then you had the 2nd DCA in Jackson interpreted another way. Florida Supreme Court went with Jackson. So what was happening? All right. Well, let's again go to some basics. What the foundation requirements for admission of documents. Okay, we've established ways you can lay the foundation, but you've got to establish again through the testimony of a records custodian. For example, 1, the record was made at or near the time of the event. 2, that it was made by or from information transmitted by a person with knowledge. 3, that was kept in the ordinary course of a regularly conducted business activity. And 4, that it was a regular practice of that business to make such a record. So you kind of want to have that, probably have outlines when you go to trial and just keep that handy. I'm sure everybody does. It's definitely a good idea. But those are the foundation requirements. So how do you do that? And oftentimes you have the records custodian testify to it. And that's what really Jackson, Moslett, the second DCA, fourth, and the Supreme Court, that's what they were really focusing on, is dealing with the records, bringing in a records custodian and establishing these elements and what's really required.
I'm having trouble hearing you.
And can you bleep that out, Alan?
Back up a little bit on your
That's
on where you were, and then I can cut it in.
Okay, you can cut it. Okay,
You
so
got to duplicate a little bit of what you had said.
Okay, that's fine. I'll go back. I'm going to go back and do that. Okay. So the foundation requirements for the admission of documents pursuant to the business records exception of 90.8036 is as follows. First, you have to show that the record was made at or near the time of the event. 2, that it was made by or from information transmitted by a person with knowledge. 3, that the record was kept in the ordinary course of a regularly conducted business activity. And 4, that it was a regular practice of that business to make such a record. Now, these elements, usually, if you can't get a stipulation, you can't get the certification, then you're going to have the testimony of a records custodian. So, and attorneys often take it for granted. They just want to use this magic language. We'll get somebody in, but it's not that clear cut. Sometimes you get away with it, and then sometimes, as in the Moslett case, and you have some other cases coming in, they're going to really scrutinize it and see, wait a minute, have you really produced someone that can really lay the foundation on these elements? And isn't it more than just repeating the language of the statute, just using the magic words? And I think that's what the fourth was doing. Moslett was they were requiring more. So there became a dispute, a conflict in the districts with respect to this first method of establishing admission of records of regularly conducted business activity, and that is, using the testimony at trial of a records custodian. So in the Moslett case, I believe that was a foreclosure case. It has been held in the fourth. They held that the witness that was testifying about the business records must also detail the basis for his or her familiarity with the relevant business practices of the company, or at the very least, give additional details about those practices as part of the initial foundation. And what the Florida Supreme Court basically said is, no, you don't. We're not going to impose that requirement. What Jackson held, the Supreme Court in Jackson in 2020, was that once the proponent of the evidence lays the predicate for admission of documents set forth in the statute, and as reflected in the case law, then the burden shifts to the opposing party to prove that the records are untrustworthy. So the Supreme Court held that the records custodian in the case before it had testified that he was familiar with the business practices of the company, and it was the company's regular business practice to record acts, transactions, payments, communications, disbursements, events, and analysis with respect to the mortgage loan account. He also testified that the documents met the other foundational requirements set forth in 90.8036, and he specifically used the language of the statute. The Supreme Court said no additional foundation is required. And the Supreme Court agreed with the second district in Jackson that when the party offers the testimony of a records custodian to lay the foundation, it's not necessary that the testifying witness be the person who created the business records. The witness may be any qualified person with knowledge of each of the elements. It's never, quote, it's never necessary to call the person who observed the matter recorded or actually made the entry. qualified witness, therefore, is anyone with personal knowledge of the organization's regular business practices relating to creating and retaining the records at issue. So, as long as the witness can testify as to familiarity with the business practices of his company and to each of the foundational requirements of the statute, the witness's testimony is deemed, at least by the Supreme Court, as being sufficient to satisfy the initial burden to lay the predicate for the business record exception. Now, when you look at Maslach, the Fourth District held that despite a bank employee's testimony describing her job duties and familiarity with the bank's loan servicing practices, she was not qualified to lay a foundation for the admission of loan servicing documents that were trying to be moved into evidence. The Fourth also held that despite the witness's testimony that the documents met all requirements for admission under 90.8036, the foundation was lacking because the witness did not testify as to specific details of the bank's procedures for inputting payment information into their systems and how the payment history was produced. So you can see what the Fourth did. I think that was in 2016, and it made it up on a conflict basis to the Supreme Court. You can see that the Fourth being very serious and making some stricter requirements that the Fourth deemed was required under 90.8036A and under the case law as it interpreted at the time. But the Supreme Court disagreed and really is making a more liberal, more lenient standard. The Supreme Court again held that a qualified witness who is testifying to each element of the business records exception has laid the proper predicate for admission of the document, such that the document should be admitted unless the opponent can establish it to be trustworthy. So I want to make sure we quote that holding so that we're very clear on that for future cases. A witness is, according to the Supreme Court, to lay the foundation for the admission of documents pursuant to the business records exception to the hearsay rule. A witness is not required to detail the basis for his or her familiarity with the relevant business practices of the company or give additional details about those practices as part of the initial foundation. Rather, once the proponent lays the predicate for admission of documents set forth in the statute and reflected in the case law, the burden shifts to the opposing party to prove that the records are untrustworthy or that they should not be admitted for some other reason, disapproving the Maslach v. Wells Fargo case from the Fourth. So, again, the Supreme Court is taking a pretty liberal and lenient approach to satisfying the particular foundational requirement of admission of a business record. There was a lengthy dissent in that case by Justices Polston and Labarga. And the dissent viewed the majority opinion as simply allowing a witness to merely echo the statutory elements of the business records exception and simply identifying employment and familiarity with the company. The dissent still believed that the witness should demonstrate that he personally has the sufficient knowledge to affirm the statutory elements of the business records exception by specifically demonstrating personal knowledge of the methods utilized by the business regarding the records that issue, such as how the records were created, what were they used for, and how they were maintained. According to the dissent, otherwise, the business records exception to the hearsay rule becomes a magic words test rather than a requirement that the records proponent demonstrate the reliability of the business records. And I guess the dissent believed that the majority's opinion, at worst, seriously undermines the propriety of the business records exception to hearsay. So I don't know. I think it's a disputed issue. There's really disagreement amongst the courts and the justices, but we've got the majority opinion out that provides this more lenient standard. But I suppose you have a burden shifting, and the other side's going to have to show how it is not trustworthy. So that is a way to attack it and make it maybe more than a magic words test. but there is a shifting of burdens. So interesting issue. Be aware of that case, the Jackson case, 298 7 3rd 531. It's a lengthy case. I encourage you to read the majority and the dissent. So that's our fascinating issue for today on business records exception and the update, which how often is that rule updated? So any questions, by all means, let us know. Again, thank you for being with Florida Appeals Journal today. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.